Okay. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. Okay, the first time, the Honorable Dr. Hidayatullah SPM as the Chancellor of Universitas Maarif Sidoarjo, the Honorable Professor Dr. Stefan Koos as our speaker today, the Honorable for Office Chancellor, and the Honorable for all lecturers of Universitas Maarif Sidoarjo. First of all, let's say thanks to Allah Subhanahu wa Ta'ala who has given us greatness, happiness, healthy, and mercy, so we can attend and participate in this special event without any obstacles. Praise and salutation upon our Prophet Muhammad Sallallahu Alaihi Wasallam, who had brought us to the path of light from the darkness in this life. On behalf of Faculty of Law, Universitas Maarif Sidoarjo, I would like to extend a warm welcome to all of you for taking the time to attend this event. It gives me great pleasure to be the anchor for this seminar, and I'm excited to be hosting. By the Generative EA and Intellectual Property Rights for today, 5 Oktober 2022, in Universitas Maarif Sidoarjo. Let me introduce myself. My name is Zahra, and I'm your anchor for today before we proceed any further. And first, let's open this agenda with reciting Al-Fatihah together. Amin, 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 ya Rabbal Alamin. And the next is Sing a Song with Any Tone. Is Indonesia Raya and March of UMAHA. Please for participants to stand up.
Universitas Maarif, Hasyim Latif Sidoarjo, Yayasan Pendidikan dan Sosial Maarif sepanjang UMAHA Universitas Maarif, Hasyim Latif Sidoarjo, Maarif sebagai mahasiswa luar biasa, dosen hebat, Universitas moga berkilau, YPM kuat, Nahdlatul Ulama, berilmu, beramal dan bertakwa. Mahasiswa luar biasa, dosen hebat, Universitas moga berkilau, YPM kuat, Nahdlatul Ulama, berilmu, beramal dan bertakwa.
Okay, the first agenda is memorandum. Okay, I'm sorry. The first agenda is opening speech. First Vice Chancellor is Miss Asri for Universitas Maarif Hasyim Latif Sidoarjo. For Miss Asri, please take your place.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin. La haula wala quwwata illa billah. Tak lupa kita sampaikan salawat dan salam kepada junjungan kita Nabi Muhammad SAW. Saya pakai bahasa Indonesia aja. Profesor Dr. Stefan Koos, terima kasih ya di UMAHA. Mohon maaf Bapak Rektor tidak bisa karena Bapak Rektor ada keperluan mendadak ke Pasuruan. Ini tadi jadi dengan terpaksa saya wakili. Yang terhormat Bapak Fajar Rahmatullah, Dekan Fakultas Hukum UMAHA, Bapak Dr. Doni Perdana, STMP, Dr. Evi Ratnasari Ekawati, sudah hadir di Bu Evi? Belum. Bapak Darno, Dekan FEP UMAHA. Kemudian acara ini juga didukung oleh dua universitas, yaitu Universitas dari Jakarta dan Universitas dari Bondowoso. Yang terhormat Rektor Universitas Bondowoso, Bapak Samsul Arifin, SPDI MAHI. Kemudian Dekan Fakultas Hukum Universitas Bondowoso, Bapak Ahmad Abrari SHMH. Juga dari Universitas Islam Jakarta, karena dulu sudah ada MoU, sekarang ada IA yang kedua, yaitu Ibu Dr. Farhana SHMH MPD, Dekan Fakultas Hukum Universitas Islam Jakarta. Alhamdulillahirabbil alamin. Pada hari ini Kamis 5 November 2023 atas rahmat Allah kita dapat berkumpul dengan mendengarkan kuliah dari Profesor Dr. Stefan Koos dengan berbagi ilmu tentang Generative Artificial and Intellectual Property Rights. Kegiatan ini dilaksanakan secara daring dan luring, diikuti oleh sivitas akademika. Juga ada beberapa teman dari Asosiasi Dekan Fakultas Hukum Indonesia. Mungkin nanti hadir di Zoom juga dari Makassar, Universitas Andi Sudirman dari Makassar. Semoga kegiatan ini dapat berlanjut dalam bentuk kegiatan yang lainnya. Kami sangat berharap ada tindakan lanjutnya, yaitu mungkin co-editor dalam jurnal kita yang sedang berkembang. Juga tahap besarnya adalah kolaborasi riset dan publikasi, dan itu nanti akan kita kembangkan lebih lanjut. Semoga kita semua dalam lindungan Allah Subhanahu wa Ta'ala dan selalu diberikan sehat walafiat, dan kegiatan ini bermanfaat bagi kita semua. Saya akhiri. Assalamualaikum warahmatullahi wabarakatuh. Selamat menjalankan kuliah umum.
Dari Bu Asri. And the next agenda is Memorandum of Understanding for Universitas Maarif Hasyim Latif Sidoarjo with Professor Dr. Stefan Koos as the holder of the chair of private law and international business at the Universität Bundeswehr. So, please, thank you, please. Thank you. Much for Mr. Stefan. The next agenda is memorandum with the Chancellor of Universitas Bondowoso and Universitas Maarif. Okay, I want to say sorry, but I want to speak my language for Indonesian language. Untuk dekan Hukum, dekan Fakultas Ekonomi dan Bisnis, dan juga dekan Fakultas Ilmu Kesehatan untuk bisa maju ke depan. Initiative Memorandum of Understanding for Chancellor Universitas Maarif Hasyim with a Chancellor of Universitas Bondowoso. Bapak Rektor Universitas Bondowoso, mohon berkenan untuk mengangkat dokumen MoU dan menghadap kamera untuk sesi foto bersama. Baik, terima kasih kami sampaikan. Oke, selanjutnya adalah penandatanganan EI Dekan Fakultas Hukum Universitas Maarif Sidoarjo dengan Dekan Fakultas Hukum Universitas Islam Jakarta. Kepada yang terhormat Dr. Farhana SHMH, yang terhormat Bapak Ahmad Abrari SHMH selaku Dekan Fakultas Hukum Universitas Bondowoso untuk bisa melakukan penandatanganan IE dan bisa menunjukkan dokumen di kamera untuk sesi foto bersama. Baik, terima kasih. Selanjutnya adalah penandatanganan AI Dekan Fakultas Hukum Universitas Maarif Sidoarjo dengan Universitas Islam Jakarta. Kepada yang terhormat Dr. Farhana SHMH MPDI selaku Dekan Fakultas Hukum Universitas Islam Jakarta untuk bisa bergabung di Zoom. Baik, mohon maaf, Dr. Farhana mungkin bisa ditampilkan dokumennya kembali untuk sesi foto bersama. Baik, terima kasih. Saya sampaikan kepada Dr. Farhana selaku Dekan Fakultas Hukum Universitas Islam Jakarta. Okay, we've got an exciting for speakers and event plan for today's is a seminar, and we hope you will find it engaging and informative. Before we begin, I'd like to take a few moments to explain the rules for today's seminar. The number one is please make sure your cell phones are silent mode or switches off so we don't disturb the speakers and other attendants. Number two, we encourage you all a participant in the discussion and ask questions related to the seminar topic during the Q&A session at the end of each session. Please make sure you keep your question brief and to the point to allow for a productive discussion. Number three, we request our attendees to refrain from any side conversation during the seminar as it can be distracting for the other participant. Nonetheless, please make sure you are safe for the duration of the seminar as it will provide a holistic understanding of the topic. We hope that you will adhere to this rule and participate fully in the seminar. Thank you for your cooperation. So let's welcome our moderator in this agenda for Ms. Ucha, who will guide the next event.
Thank you for the host, Ms. Mila. Assalamualaikum warahmatullahi wabarakatuh. Good morning to all of invited guests, audience, online and offline, and our special speaker today, Professor Dr. Stefan Koos. Guten Morgen. To all participants, thank you for your attending this public lecture. Before all, my name is Saidatun, and I will be the moderator for today at this public lecture. Mr. Stephen, can you please take your seat? Thank you. First, let me briefly explain the order of the session. Professor Stephen will deliver the presentation about generative AI and intellectual property rights. Before that, we all know this word, especially Indonesia, has entering the new era for the globalization. The 4.0 era has become 5.0 era in our society. In this era, technology has become more evolved than before, and also those influence our academic field. The newest technology, such as ChatGPT or something like that, indirectly become our new friend. So that learning more about how to manage and control this era is important to us. So we are glad that Professor Stefan Koos is here today to enlighten us more about generative AI and intellectual property rights. After Professor Stephen delivers his presentation,
I will open the question section to our beloved audience, both online and offline. In that section, I will accommodate 3 questions maximum, hopefully in English, from the audience. One by one, of course. But before that section begins, Professor Stefan Koos will deliver his presentation. Before Professor Stefan deliver his presentation, let me read his short biography. Professor Dr. Jules Stefan Koos, born in Hagen, Westphalian Federal Republic of Germany, grown up in West Berlin Federal Republic of Germany, studied law in University of Würzburg, Germany, became judge in 1994 or 1995 at a district court in civil law, agricultural law, criminal law, guardianship law, graduated from doctoral at University of Constance, Germany, postdoctoral teaching qualification at University of Constance, Germany, holder of the chair for private law and international business law at Bundeswehr University of Munich, Department of Economic and Management, temporarily become consultant of World Bank in 2013 until 2015. Since 2011, visiting professor at the Law Faculty of University Islam Riau, and since 2017, visiting professor at the Law Faculty of University of Erlangga, Surabaya. His areas of research is civil law, competition law, consumer protection law, cyber law, and conflict of law. Has a multiple publication in law area, of course, and his master's is legal framework for the post-pandemic tourism in Bali, published in 2021. Without any further ado, please welcome Professor Dr. Jules Stefan Koos. Allocated time for you is around 45 minutes, and thank you. You can start your presentation, sir.
Oke, sorry. Ini harus ya sudah. Ya, selamat pagi. Itu mungkin saya ke sini ya, lebih baik. Ya, oke. Itu teknologi tua, tidak teknologi internet 5.0. Biasanya saya suka jalan-jalan, tidak duduk kalau bikin presentasi, tapi hari ini ada ini ya, so mungkin itu nanti sulit. Ya saya kira saya harus mungkin campur-campur di kuliah itu, tapi saya tidak mau campur-campur karena ada sudah moderasi di bahasa Inggris. Saya akan pindah ke mahkamah bahasa Inggris sekarang ya. Nanti bisa membaca semua karena itu tadi bilang Bali itu tidak yang terbaru itu, dan itu juga tidak yang terpenting. Itu karena ada seminar di luar Madura dan mereka selalu mau berbicara tentang tourism dan local wisdom dan itu. Tapi yang terbaru adalah ChatGPT di legal research, dan kalau mungkin itu terlalu cepat sekarang, nanti bisa membaca itu ada di research gate saya, namanya saya, dan ada beberapa publikasi di sana di beberapa jurnal Indonesia tentang artificial intelligence, ChatGPT, dan juga yang penting displacement of the law by technology. And now I change to English. And this is the most important aspect. I don't want to talk only about actually the ChatGPT and the legal aspects of the ChatGPT, especially about what happens with the future of the the copyright and the intellectual property, I all these topics about liability in AI, about artificial intelligence and intellectual property into a wider framework. And the wider framework is, you mentioned 5.0 and 4.0. These are actually useless terms, yeah, because anybody uses this, like disruption. All the time people talk about disruption, but the wider framework is that we have a disruption here now. We have a disruption because we have indeed a replacement of the law by technology, and a replacement of humanism and of human flexibility by technical determinism. And the most, for me, one of the most disruptive, or maybe the only disruption for the law is the artificial intelligence. First of all, because the artificial intelligence is changing the framework of our contract law, for example. We have not declarations of intent anymore in the future, maybe if AIs do something. We have determinism in smart contract combined with AI. We have, for example, in the competition law, we have the term of the behavior, the anti-competitive behavior, which is also maybe not valid anymore in the future if we have algorithmic market behavior or market actions. So this is very innovative and very disruptive, and this is the first real disruption. The internet was not all disrupted. So everything you see in this presentation is done by generative AI. The pictures are done by generative picture AI, DALL-E mostly, and I just must go a little bit to the practice before we go to the legal questions, because the legal questions also depending on the practice. And the first of all, one question, the legal question is the bias. And this is what comes out if you tell the DALL-E, please write, make a picture of Professor Dr. Stefan Koos and my colleague, Professor Michael Bohne, or how would look like the law professor. And you see this is bias. Why a law professor must be a white person with an old-fashioned pomis and a Western suit? Why it cannot be an African professor or a Japanese professor or a Japanese professor? Why it's a Western professor, the law professor automatically? And this is exactly one of the problems we have, which is dangerous for the society, for the creativity, because we are biased and we are influenced by the bias. And also, it is connected with many legal problems like data protection, the truth of data processing, for example. That's why Italy banned the ChatGPT for certain weeks, some weeks, also influencing the creativity and the society and the legal and the public opinion about things. And first of all, just very short, because we don't have that much time. What is ChatGPT? Important is one aspect. One aspect is the most important. The rest you can read in the Wikipedia. But one aspect is GPT, GPT-4 are generative pre-trained transformers, generative pre-trained. They are generative because they generate something. They pre-trained because they are trained with many data, with many texts coming from the internet, or pictures coming from internet, coming from public, accessible, crawlable, accessible sources. And that is not only applying to ChatGPT, also to Ask Claude, Bound, also the system of Meta. This is all nothing else than neuronal systems which are trained with a lot of texts or a lot of pictures. And that what they do is statistically, they statistically guess if a sentence starts like that, or the question is like that, what would be statistically likeliness for the next answer? And as they have a big experience in the untechnical sense, yeah, because it is trained with many texts. So the statistical model is already quite good, really surprisingly. So, but what is important is, because it is so good, because it is so good trained with millions of texts, we have two issues with that. One issue is that the bias is coming from that, exactly from this amount of text, because you can ask yourself, how many people in the world would make the Google research like that they say women should work and should be an independent life from the husband in the world. I mean, the West is not the center of the world, right? In the world, there are many cultures where they say, okay, if any women should study, but then once they marry, they should be at home and cook for the husband and cook for the baby and for the child and stop to work. Yeah. So how many people in the world, how many percent in the world you would think people Google, when they Google, they do their own bias into the Google research, which is not very feministic. And how many people are really feministic? This is some people from the West. So, but this is not the majority in the world. Yeah. And as it is trained from that, of course, the statistics will often get something which is biased in that way. And this is exactly a problem for what I mentioned before, for the wider framework, for the replacement of the law by technology, because it leads to an influencing which we cannot control anymore with legislation, because it is a platform, and this platform is not located in our countries. We cannot switch off the servers. It is a platform which is ubiquitary, and this is a contradiction to the territoriality of the law and of the sovereignty of states. And the ubiquity is replacing territoriality, and that leads to a crisis of the international law indeed. And that is dangerous and a problem for the whole society. This is not only connected with the ChatGPT or with the AI. This is already connected with all platforms. This is already with the data protection. If Chinese companies want to sell augmented reality glasses, and these augmented reality glasses are connected with the internet and send data to China, what won't Indonesia do to protect the citizen, even if you have finally then Undang-Undang Pelindungan Data Pribadi? Yeah. You can, of course, find Huawei or Tamu or also American platforms, but will they respect your legislation? This is questionable. They will only respect your legislation if your country is important enough politically and economically that these big technological concerns in China, in the United States mostly, respect your legislation, because they have incentives to do so. And that's why I always did not agree that Britain did the right thing to make exit Brexit, because as small countries, we have no power to enforce our law internationally. But European Union still can do that, and America still can do that, and China still can do that. This is important, but most important is that people use the ChatGPT. Some people use the ChatGPT as a vendor Google, and this is exactly the mistake. I was asked in Erlanger by one student, isn't that a bad product? Because we know it is hallucinating. It is making up facts which are not true. And indeed, it's hallucinating. Isn't that a problem? Isn't that a bad product? How can this company bring out this product which is not mature to the market? This is not at all a bad product. It is a product in the market which meets the interest of a lot of people who have no idea how to use this product. This is the point. Yeah. Is it a bad product if you have a car? If 10-year-old children start to drive around with these cars and make accidents, no, the car is still a good product. But we did not make advertising for any children and anybody without a driving license to drive cars. So actually someone needs an AI driving license for using the ChatGPT. Before opening this ChatGPT, you must know it is a statistical model. It is not logic. In the moment, it is still not Googling. It will Google, but it is not logic. It doesn't know anything. It has no ethic. It has no moral. It has no logic. It is just nilai statistic. Yeah, that's all. And that's so important. I encourage you expressively, if you not have an account, open the account still this today, and don't wait, because you will be legal professionals. And as legal professionals, I'm glad that I'm already 57, because as future legal professionals, you will come to a situation where it is questionable whether you will be needed in the labor market or not. Yeah, this is very clear for me that maybe 1/3 of you will have a job as you maybe awaited it before. I did not believe that, but this is really, I must really say it so clearly. Or you are able to use these things as controllers and prompters and you are willing and able to do it, or you say, oh, it's not so important, there are specialists for the AI and for the IT, and I leave it to them, and I just do my normal legal work, I'm a good lawyer. It will not be so important anymore whether you are able to write good papers. Because the papers, and I come back to that later, the papers are absolutely irrelevant. What you produce in words, in letters, is absolutely irrelevant in the future. Relevant is your idea and how you bring the idea to the tool and how you use the tool to express the idea and produce the product. That's important. And that is the job of the lawyers of the future. You will not write drafts anymore. That will be done by algorithms. But how you process it, how you control it, that is your work for the future. So I just want to give you an example for that. I was preparing a text about cyber notary in Indonesian law, and I had this text already published. You also find it in a research gate, and then I wanted to know what it produced me. I must admit that was the GPT, the cheap version, the free version. The GPT-4 is a little bit better, but also makes this mistake. And that is still, yeah, okay, but it's typical when universities ask me, should we accept ChatGPT in research and teaching, and should we allow our students, or should we ban them? Banning that is absolutely nonsense, because you will anyway not be able to control it. Yeah, how you want to prove that someone used this? Okay, put it to a scanner. The scanner says in text, I wrote totally alone, says 30% AI, but it's not AI. Or it says no AI, and it was 100% AI. So you cannot ban a student because of fraud if you cannot really prove it. That is the rule of law. It is absolutely not provable whether someone used it or not. And also, you must prepare the students for the later work. And if they cannot use this tool, they are not well prepared. They are not well prepared. Universities have the purpose and the duty to prepare the students for the use of these tools. So I encourage my students to do that, but I want to know how they do it. And the form of testing them will be different. So there will be more importance for oral testing, for defending their ideas. I want an annex with the prompts and all these things. But that is crucial at universities do that. So what it produce here anyway, it is not interesting. And it is absolutely, I don't know if you had the occasion to read that. Sometimes it is also even not good, not right, but it is absolutely typical blah blah. Yeah, without any creativity. This is absolutely nothing, because people think they just ask, write me a thesis about cyber notary in Indonesia, and that comes out that. A good use of the AI is incrementally prompting. So you give the AI an idea about what you want, a brainstorming with some aspects you already know. This means you must already know your topic before you can use the instrument. If you have no idea about the topic and you use that instrument will produce you some boring things with mistakes you don't even understand where other mistakes are, and you will not be able to control it in a proper way. So if you are an expert of your topic, then you are ready to use ChatGPT to write a paper. But before you have done your research, please use it only for trying around, but don't try to make a paper of it, because that comes out. And then the next step was, then I asked the algorithm, what is the UETA? This is okay, this is more or less correct. And then I asked it, does the UITA mention cyber notary? It says, yes, the cyber notary is recognized in the UETA as the concept of cyber notary, and interesting. Or notaris elektronik in Indonesia. And I don't know how many experts of notary law here are here, but there is none of this term. There is no notaris elektronik in the law. In the elucidation of the notary law, and not in the UETA, is written the term cyber notary. But the issue in Indonesian legal discussion is that nobody knows what the legislation means with the term cyber notary, because it's not really elaborated what it is. It's just mentioned that one of the tasks of the notary is also the cyber notary, that's it. But not notaris elektronik. Why it writes that? Because it's statistic. It thinks, oh, Indonesia, and cyber notary is an English word. Of course the Indonesian legislator would use notaris elektronik. So logically must be or cyber notaris elektronik. I mean, how many of you would have noticed this mistake? So if you are a lazy student and you just let it write something, then there's this mistake. And this mistake, I would let you really not pass the exam. And if I find in the future these mistakes in paper of my students, I will not let them pass. Yeah. And let me also say that in the future, I don't want to have any papers as a reviewer of Indonesian journals with Indonesian English. So that you write it originally in English. We all know native speakers. And anybody of my old papers who reads my old papers sees that I'm not a native speaker. And I was to really send it to Jakarta and let it translate or so. So I just write it on my own and then check it out. But it's still not good, yeah? This is not necessary anymore. ChatGPT leads to a democratization of the research of non-Anglo-Saxon researchers, because before we were under the imperialism of the Anglo-Saxon research, because the Anglo-Saxon countries made the conference, even if it's not in their countries, they force us to speak English, and then their participants are always having an advantage because they speak native speaker English and we are only learning that, and they're always better than us with that, with their language. But in the future, we can publish like them, because we can use the ChatGPT for making our papers in a proper way. So I don't write my papers anymore in English. I write my papers in German, and then I let it translate it, and then I let it go over it, and let the AI propose me improvements. And is there something missing? Should I add something? Oh, I have another idea. The following idea, that I write it very fast in German. Say, can you tell me, is that relevant for the topic? And then it gives me suggestions. Sometimes the suggestions are irrelevant. Sometimes the suggestions are not bad, or it meets my expectation. And then I ask it how to integrate it the best way, and then I integrate it. Yeah, but this means I'm still the expert, not the AI is the expert. I'm the expert, and as the expert, I can use the tool in a proper way. But as you're not the expert, you cannot use the tool in a proper way. So this is a lot of lie. Maybe the legislator should take it. It outlines the requirements for becoming a cyber notary in Indonesia, obtaining a license from the Ministry of Communication, Information and meeting certain qualifications. Very interesting, yeah, that there is a license even in Indonesia. It has obviously no idea about the concept of the cyber notary as it is discussed in the Indonesian literature. So just short, and then we come to the legal aspect. What can it do? It can write in general introductions, overviews. Every lecture, every paper here has boring parts. Yeah, especially in Indonesia, it's so formal. So I always must write about abstracts and methods. This method is always, yeah, this is a normative legal study. Of course, normative legal study, because I don't do any empiric. You would see if it's empiric, right? It's always the same, and then even citing something with something right about normative legal. This is absolutely nonsense. It's not necessary, yeah, but it makes the papers full and cost me time. So I let it write that. I let it write the abstracts in Bahasa and in English. I make the keywords. The keywording, I hate it. It also makes the keywording, makes it quite good, yeah. So boring parts, or we already published something before, and now we want to make a new article with some amendments or something new, some elaborating more. Then we always must make the introduction, and we must, of course, bring the reader to the start before, right? So, but we cannot just copy our articles from before. So I give the ChatGPT the blogs from before and tell the ChatGPT, write it new, but write what I wrote here. Yeah. And is this unethic? Absolutely not unethic, because first of all, it is my own ideas here. Yeah. But what I said before, the papers, the words, what you produce is irrelevant. Is nobody interested anymore. Yeah, because any idiot can write a paper with that. But not any idiot can give the AI ideas to write a good paper. But the wording, any idiot can do that nowadays. And that is also important here when I say modifying formulations. Yeah, of course, you can use it in an unethical way. You can, if you haven't, I don't know how many of you have an idea about growing roses. I have no idea about growing roses, but if I want to be an expert in growing roses, then I look for some papers about how is growing roses and which kind of roses there are and what fertilizer they need and so on. Feed the AI with that and tell the AI, make me a paper, read first this, answer with yes. Read first this, answer with yes. And then now make me a comprehensive paper about growing roses. Yeah, I have no idea about that, right? So that's why I want to test my students orally whether they have an idea about what they wrote. So then I know that this is an AI product or their product. But what I want to say is any idiot can take my books or my papers and make something new. And what it means is the plagiarism is anachronistic. Nobody will be interested in plagiarism anymore. I'm sure you care for plagiat here still, yeah? But plagiarism, only the most stupid of the stupid people will make plagiarism. Because if you have a little bit idea about to use this tool here, nobody needs to plagiate anymore. You know, because you just take a text of someone else and let it work about it and then make something new with it. For what plagiate? Yeah. So this is from before yesterday. It can summarize text. This is important for the intellectual property because, of course, it can go behind the paywalls, and summarize text which I should pay for, yeah, and then give me a summary for what I should pay the text again, yeah. So, for example, proofreading text, of course, and the most important, can brainstorm and can develop your concepts and structure. That is what I do mostly. When I need a new lecture, I give it for what is that lecture? Es satu, es dua, who I am, a German professor, but want to focus on Indonesian law. It should be for 90 minutes. I need around 20 or 25 slides. And then now give me structure about the following topic. And then it makes me a structure, and then I can say, and then I can see, oh, the structure is not so good, or the structure I must modify, and then I say, now give me the presentation. And then it makes me a table of the presentation, and then I can work with that table and then can elaborate in the slides what I want to say. Yeah, this is very important. And if people are afraid of starting their master thesis or bachelor thesis, because it's a hard work to make a structure, yeah, I'm not afraid of that anymore. Before, it took me maybe 3 months to make a good lecture and a full presentation. Nowadays, I make lectures in 1 week. If I have an idea about the topic, of course. If I must learn about it, of course not. Yeah, but if I have an idea but not yet have a presentation, and I want to make a structure which is didactically good, then I let me use the help of this tool. And this is absolutely ethical because this is still my intellectual ideas I integrate here. However, of course, again, but this is important for intellectual property. The result is irrelevant. I don't care about the result anymore. And this is important because, why? Because intellectual property rights protect results. The patent is protected. The work is protected in copyright, not the idea. The idea is not protected. But in the future, what is relevant is only the idea, not the result. And this means the whole intellectual property rights system might be disrupted by these developments. So, which are the legal questions? I already mentioned the data protection. We will not focus on that today. We will talk about AI-generated work is copyrightable. Is it or not? Who is the creator? And how we assign the products of the AI to someone. What is with the copyright infringement? And also, in the end, I hope we can talk about the ethics of the use and the future of creativity and the writing. Now, let's start. Who is the creator? If I use ChatGPT, I use AI, is it copyrighted work of you? And this is already a question because AI is not a person, right? At least on the first side. And actually the copyright law, is the same. It says that, this is just an example, the German copyright law, it says works within the meaning of this law are only personal intellectual creations. Creations, not ideas. So this is first of all, the result, the creation. Second, it is intellectual, and third, it is personal. And all of this is not applying to algorithms. So before we go into the deep, we can already say, or we say that the product, after we're using the AI, is our product because we somehow use it as a tool. I mean, if I paint a picture and I use the tools for that and the color and the paper where I painted is also my work, right? This is just a tool. How much must something stay near the person, or how far it can be independent from the person to be not a tool anymore? This is the main question here. And the question indeed is it the author's own intellectual creation? And in the EU law or in the Indonesian law, we only have the copyright law in that sense, that it must be from a person. And the New Zealand law and the British law, I don't want to go into the deep, we don't have that time, but in the British Copyright Design and Patent Act of 1988, it says in the Article 9 CDPA, in the case of a literary, dramatic, musical, artistic work which is computer generated, the author can be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. So this would be a model for that, indeed. Yeah. So because this is interesting actually, because the CDPA assigns something to a person. So this is a general topic I always identify at the beginning of my lectures of Introduction to Private Law: assigning of risks and assigning of effort and assigning of results. So here we assign something. Actually, this is an economical idea. Because if someone uses the tool and trains the tool and produce something with the tool, this one is investing something. And investing brings the assignment of the result. Why someone else should profit from what I invested. Whether I invest with money or invest with work or invest with the technology I train, doesn't matter. It's investment. And investment brings reward. Yeah? This is actually the idea behind that. And that is, it's a model we can indeed use in a certain way. However, you see, computer generated there is no human author in the work, and important is the copyright law in Britain does not know moral rights in that sense. This is understandable because the creation of a human being is part of the human personality. So the copyright law is actually developed from the human personality. It is not absolutely differentiated from it. We have still the monistic theory, and some countries have the dualistic. We follow more the monistic. We say the copyright law is something which is an intellectual property, of course. There is the moral right, and there is also the commercial part of the copyright, but it is everything still combined with the personality of the person. My book is my baby. Yeah? But if I invest something, for example, I make you a celebrity, I'm a television station, and I come here every day, make a whole story in your home and make you influencer and make you famous, then invest in your person. Maybe nobody knows you, but later anybody in Indonesia or the world will know you. You will be famous, and I can use you for advertising. I invest in you. Yeah. So the prominence, the celebrityness, should be protected in a certain way also as a certain intellectual property, right? So this is exactly the principle behind it. The European law is not like that. So in the European law, we differentiate between the conception, the execution, and the redaction, and the output. And that is what is protected. What is with the idea? The copyright law is not protecting the idea, and we also don't have this workable concept in the British law. This means for our law systems, like Indonesia and European Union, we would say we must differentiate whether the A is just a tool of the human creator, then it is copyrighted. If the AI decision, if the design decision is shaped by the AI to mostly by AI, 90%, or absolutely totally anonymous by the AI, then there is no copyright because you cannot assign it to a person. It is not a tool anymore. It is the creator. And if the design decision is by human and AI partly, that is a different point, because then we must assess how strong, and we must decide how strong must be the participation of the human being in the making of the product. And this is not clear, and this is not decided. This is a discussion, although which includes ethical questions, because we must protect also, of course, the human aspect of the copyright law and the personal aspect of the copyright law. So this is really a difficult question. I don't have a solution yet for that. But of course, we see there are concepts like work made for hire. Work made for hire, for example, is a concept where the employee creates something, and the boss of the employee has the intellectual property right and can use it, yeah, because of the labor contract situation. Of course, the AI is not the employee, but we can. This is also in the liability questions used for the AI, for example, self-driving cars, mega damage, and so, or algorithmic market influencing. We sometimes discuss agent theory. So we say the AI is actually an electronic agent. This is a term from Indonesian cyber law, electronic agent. but not, I don't use it in exactly the same way, but a little bit like this. The smart contract, for example, can be an electronic agent. So if it's an electronic agent, it can be also an electronic worker, right? So, and I can say there's a parallel, an analogy to the work made for hire by an employee. This would be a possible concept maybe for that. So, who owns the results if not us? If we really make it free with the AI and we don't influence much, who owns the result? And this is, first of all, we must say the owner of the software, the platform is not owning that because they say we don't own the results of what we produce with our tool here. So the question is, can the AI own the results? And this one is an Indonesian citizen. That one is a monkey from Sulawesi, I think. And this monkey is very famous. This is Naruto. And Naruto was in a jungle, and there was a photographer, and this photographer made a break, and then Naruto found the equipment and made a selfie. And the photographer later found the photo, and then, of course, posted it everywhere, and then also exploited the photo and made royalties with that photo. Yeah, so it was very famous, and they were advertising with that, and so on. Now, in 2018, there was a case in the United States in the Court of Appeals of the Ninth Circuit. The people for the Ethical Treatment of Animals Incorporation, short PETA, it's an animal protection organization, NGO. They said, why this photographer should have the royalties? Why not the monkey? The monkey made the photo, not the photographer. So the photographer should not have the money. The photographer should give the money actually to Naruto. However, unfortunately, nobody knows where Naruto lives now. So there's no address. So then PETA said, yeah, then we are the best friend of Naruto because we protect animals, right? So we claim that the photographer must reimburse us the royalties he earned with the photo of Naruto because we protect PETA, and in the US law there's such a figure like the copywriter's best friend who can claim and get sued someone that because if the person who is actually the copywriter cannot do that in the moment, yeah, so maybe has no legal capacity. So the question, the court had to decide two questions. First of all, is Naruto a legal person? So can Naruto have a copyright law? And only if that is answered with yes, the question is PETA the best friend of him? So the second question is not so generally interesting, but of course, why PETA should be the next friend of exactly that monkey, right? And there are many animal protecting organizations. Why exactly PETA? So of course, the court said, why PETA? Yeah, PETA is not the best friend and the next friend. But is Naruto a legal subject? And this is depending on basically two theories, which also are discussed in Indonesia. The first theory is the fiction theory, and the second theory is the reality theory. Fiction theory means these bottles here, they are treated very badly normally, right? The people drink it and then they flash it, crash it, throw it away, burn it. It's not nice. Let's say we have a legislator who makes unimportant things and just makes joke, yeah? The legislator makes undang-undangan perlindungan botol. Paragraph 1, undang-undangan perlindungan botol adalah legal subject. Pasal 2, kalau ada orang hurt botol itu, ada punishment or something, yeah. And then the Organization for Protection of Bottles is the best friend and can also make damage repair claims, yeah. So something like that. It's ridiculous, right? But we have that. For example, Savigny, yeah. Savigny is actually the one who is the protagonist of this fiction theory in the German legal tradition. If you talk about Yayasan, a foundation, you can also ask yourself why a foundation is a legal subject. I mean, why human is a legal subject? Human is a legal subject because we are human, and that is part of the human dignity. The human dignity doesn't allow us to say that a government or a legislator or a parliament as a legislator can decide that this person or certain person in the society is not a human, is not a legal subject, because that would be infringing the personality right in the form of the legal dignity of the human dignity, and the human dignity is from the nature law, something which cannot be changed. We are not legal subject because some government or some parliament says so. So even if 99% of the Indonesian citizens say we don't want that, I don't know, oleh are legal subjects, and the parliament makes a law to deprive oleh of legal subjectivity, this would not be law. Because as a oleh, I'm also a human, and a human is automatically a legal subject from beyond the law. Whether you follow the religious natural theory or you follow the positivism of Kiel says over the normative rules, there is something which hangs the normative rules above the human being, and this is actually the human dignity. Yeah? So why Jaya-san, why the foundation is now this legal subject? Because it's not a human. Because we have at least a humanistic background, because it's the idea of human who makes the foundation. The foundation should act in a certain way, in a certain idea this human founder developed. And that's why we can say there is a humanistic basis for making, in the reality theory of Otto von Gierke, to make the foundation a legal subject. The same happens to associations, a group of people. These people want to act together for one purpose they have in common. So there is humanistic basis. With the fixed theory of 7E, we can do everything. There's no real basis for making a bottle a legal subject. But if the legislator says the bottle is legal subject, then it is legal subject. We make just a fiction that the bottle is treated like a human. Ridiculous, but can be for pragmatic purpose, of course, possible. And of course, we can also say the foundation, the associations are legal subject because it's useful to have foundations and associations. That's a fiction theory. Now, if we go to the monkey, if you ever look into the eyes of a suffering monkey mama, and I did in South Africa, I saw Pavian mama with that baby, and I had to pass this horrible pavian. I hate the monkeys. I really hate them. I'm really afraid of them. But you must really pass these monkeys when you want to go to certain points of interest. And there was this mama with the baby, and I never saw something so sad. I must even cry now, and it's not ironic. So sad, like this monkey mama understanding that this baby is not moving anymore. So they feel. They have emotions, right? Whether you say it is okay to give them the same right like humans is a totally different question. But if the legislator decided, okay, humans should be protected as legal subject, there is sort of at least similar to a humanistic basis because it is a suffering, feeling, and emotional being. Of course, we would not do that with amoeba or with bacteria or virus, yeah. But of course, with monkey we can do that, or with bats maybe not, yeah. But monkeys, why not? Some countries even say that nature is a legal subject. This is at least something philosophically possible. What is with the AI? Can the AI be a legal subject? I mean, the Tesla, the self-driving car, wants to protect his driver, and there is a ball in front of him. The Tesla sees there is a ball, a hard goal, but on the side there is just Ibu walking. I just drive into the soft goals, the soft Ibus, then my driver is safe, better than to drive against the wall. The car makes the decision. Let's say the AI in the car, the algorithm makes the decision. Is this comparable with the decision of a human being? Can we really say there is a parallel of emotion? It is absolutely deterministic. It is not emotion, depending on how it is programmed. Right? And if I ask my students, for example, now imagine here's a table and we put a little baby in. This baby is cute. The baby is innocent. And someone tells you, someone with higher power tells you, you have the choice. You kill the baby and then 10,000 people, children, women, older people, men, women, are protected, are safe. Or you reject to kill this baby, then 10,000 people will die. And I asked the students in Germany and Indonesia, what would you decide? The male students often say, of course I will kill the baby. Yeah, this is logic and this is rational. Yeah, save 10,000 for one. But in Germany, we have already a decision of the Constitutional Court about that. It says it is against the human dignity to calculate 10,000 against one life. Every life is as much value like 10,000 lives. So you cannot just say, of course, one life must be killed for saving 10,000. This is a dilemma, right? This is actually the Abraham dilemma, what we talk about here. And the women often say, well, I don't know, maybe not. And I swear, I cannot decide that. I cannot say, no, I would not. I cannot say I would. Yeah, I would stand in front of this baby, and then I would say, should I do it? And I would say, why is higher power let me make this decision? Is this a fair decision? I don't want to decide that. So I will get out because if for example, if some terrorists say we will kill these people if you not pay, right? And then are we the murderers? Are we the killers? No, the terrorists are still the killers. Yeah. So if I not decide to kill a baby to save someone, then I'm not the killer of the 10,000. I just not do the decision. It's not my decision to make this test here. Yeah. What I want to say is, what would the AI do? The AI would do what it's programmed like. Yeah. So for example, the AI is programmed to always save the driver whatever happens. Then it will kill the evils. Or the AI is programmed to the driver is the one who is responsible because for him is the car. The driver should not do that on the cost of other people, so it will kill the driver. Or the AI is programmed in any case, never make a decision which is harming people. Then the car would just switch off and not make a decision. This is also in the robot law of Isaac Asimov the case. The robot should never harm human, whatever happens. So the answer is the AI cannot be, because it's no parallel and no other analogous to the human being, cannot be from a reality theory, a legal subject, but from a fiction theory. If it's pragmatic, we can do that. But then the next question is how the AI should pay the damage repair. Yeah, even if the AI makes damage, where's the money from? The AI is not having money, right? So we need pool system and so on. This is a different topic. We can make a presentation on its own about that. So the next question is the output generated of the AI truly originally? But more important is it a copyright infringement if we use the ChatGPT? I mean, the ChatGPT use data, which is used for training, and the ChatGPT produce something, and it is not so clear whether it is producing something which can be infringing copyrights of others, because normally it makes something totally new. But at least it is trained with data, with texts. So in the United States and Germany, there are now several cases where artists, authors sue OpenAI or also the other holders of these algorithms because they trained their product with their copyrighted products, which are in the internet. If you ask ChatGPT itself, it says, I am not able to infringe copyrights because I only use open accessible sources in the internet. But we all know that open accessible doesn't mean that it's free of copyright. It's not public domain. So what it does is it uses public domain and non-public domain copyrighted works to train it. It does not copy these texts in the output, but it is trained with that. And it's trained with that for producing a product, for making a product. And this is the ChatGPT, and they sell it for $20 per month. And later maybe more expensive. Yeah. So some artists found, for example, a burning tree in one picture that Dal-E made. A burning tree. The picture was new, but there was a burning tree he painted in one of his paintings. So the Dal-E was inspired by this tree and took this tree and put it in a new painting. Or authors find ideas of their books. And here we come to the problem. Ideas are not copyrighted. Only the text is copyrighted, and it depends on how close the result is to the text which is copyrighted to say it's a copyright infringement. Mostly it is not close enough. This means we have a legal gap. The copyright is not protecting that. I want to raise the question, therefore, whether it's copyright infringement if they use copyrighted text for training their product and shaping their product. Or is it protected by another intellectual property right, or should it be free? Is it maybe only free inspiration? And for that, I want to give you a very old slide here. I made that slide many, many years ago for an Indonesian conference or about protection of cultural heritage. When I made my first presentation in Indonesia, all the time someone in the audience asked me, Prof, there are so many dances and songs, and there is batik, and there is rendang, and I don't know what else. What is with that? And then I asked him, what do you want to know about that? I really don't need dances. songs. But what is the problem here? Until I learned that this is a big issue for Indonesian, that Malaysia is all the time claiming that everything which is actually Indonesian culture is actually Malaysian. Batik is Malaysian, Rendang is Malaysian, Langa is Malaysian, everything Malaysian. Yeah, because a Malaysian tourist ministry is very clever, and they really do that and really know to make this is Malaysian culture to the Boleh tourists. Come to Malaysia, learn about Malaysian culture. But actually, nobody in Malaysia wears batik. Yeah, we wear batik here. Yeah, but not in Malaysia. So why it is only Malaysian? Yeah. So I don't want to talk about that, but this is the issue of Indonesia, and Indonesia and India all the time wanted to have that in the trips, and it was always a problem because this kind of intellectual property right of the budaya is a collective property right, which is not fitting to the individualistic concept of the intellectual property right in the other way, right? So in the Hak Cipta, the Indonesia has that rule. There's a copyright for budaya, for cultural heritage. The question is it a good law? Is it a good law? Is it really useful? The Indonesian government can claim, and then actually the idea should be used for the masyarakat there, but I don't know how far it is really used for the masyarakat, or just go to the budget of the state generally. I don't know that. And also I have a problem with the concept generally, because the concept is actually potentially, if it's not done in the right way, can be racist. Because who is part of the budaya here? Yeah. If my parents already were in this kampung and my grandparents moved to that kampung and I'm born in that kampung, maybe I don't speak even German anymore. Am I part of the budaya? Most of you would say, no, you always believe. Yeah, because I look like that. Yeah, I'm not Malayan. I'm not Javanese. Yeah. But actually, I'm budaya when I identify me with this culture. So if I'm living since decades in Indonesia, even if my Indonesian is deficient, and I identify with Indonesia, with the culture, actually I should be also part of this culture then. But at least I should be part of the culture if I'm already in the second generation here. Yeah. But this is, yeah, you see blood. Yeah, blood. You have got Indonesian blood, so you're not part of it. Dangerous, potentially racist, yeah, problem, really a problem. But what is more interesting is, if you ask even local artists in Indonesia, in India, in other countries where they have strong folklore, do they want this intellectual property right? And a big percentage of them says, we don't want that, we don't use that, we don't need that. Why? Because human culture is developing by inspirations. The whole human culture in the whole history was always inspired. You have no pure Indonesian or Javanese culture here. You have a culture which is already inspired also by inspirations and by influencing of the Dutch, and before of Hindu cultures, and later of Arab culture, and now of American cultures. So everybody, in any time of the history, we were inspired by others. So Buntut, for example, you might say this is Indonesian, but so Buntut is something my mom used to make, and my mom had no idea about Indonesian kitchen. A part of that sop Buntut was not spicy, but the rest is actually a European soup. Maybe coming from the Dutch, I have no idea. The bakery in my hotel breakfast is all Dutch bakery. A part of that you use pandan. The Dutch didn't use, but the way it tastes and all these croissants everybody eats here, this is all influencing. Yeah, we all the time influenced by cultures. German is not, we have no Germanic culture. Yeah, nowadays we have a world culture. So of course we preserve certain aspects, certain peculiarities of our culture, but nobody has a pure culture. So to use this intellectual property right in a consequent way means we try to stop the development of culture. That is what some artists say, and I agree with that. So I don't think this is a good way to protect, because actually, and this is really coming back to the digitalization, actually we have ubiquitary society, we have platforms, and the platforms influence us all the time. Some people talk about Americanism. We are all Americanized in a certain way. But why we are Americanized? Because many people think this is good. Yeah, I don't like Anglicism when my students use Anglicism. I told them in the beginning of every lecture, I don't like Anglicism. If you write your tests, I read Anglicism, you will not get, you will pass, of course, but I will not be happy. So if you want to make me good mood, then don't use Anglicism. If there is a German word, use the German word and not the English word. Yeah, because if we are interested to preserve our culture, then we don't need to law for it. And that means even in the ubiquitary digital society, the world society, we can keep our culture. Now think about people in Mataram. Someone asked, Prof, there are so many, we have so many nice songs here in Mataram. The Sasak song, so nice. But when I go to the street, in Singigi, in Kuta, in Mataram, I often hear Western music. What can the law do? Yeah, what should the law do here? Force the people to keep their culture? No, if you want to keep your culture in the future, in the digitalization, with ChatGPT, with bias, with platforms, with metaverse, then it's on yourself to protect your culture. If you are interested to protect your culture, you will keep your culture. But if you're not interested in protecting your culture will be influenced by other cultures, and then it will step by step disappear, or it will be mixed with something else. So this is a totally normal development, which is not always negative. Bali, for example, Java, for example, go to Jakarta, they all speak Javanese there. There is a lot of Americanizing things, right? But they're still Javanese, they will be always, yeah? But if a culture doesn't want to be protected, then it will not be. So what I want to say is, this is the socio-cultural dimension of all the digitalization, but also of this ChatGPT and the AI. What I want to say is, this all will have influencing, negative sometimes, positive sometimes, effect to societies. Yeah, because we can be biased if the majority of the people believe what it produces. We will lose our culture if the majority just moves around in Instagram. We will lose our culture, and you will lose also sort of your moral here. Moral, I talk not about ethic, I talk about the moral, because moral is the customs of a certain group, not the general moral, the general ethic. Yeah, so ethic is something which is pluralistic. But if we talk, for example, about the definition versus pornography, you have a totally different idea about that we have in the West. Yeah, so what we have in the West in the 2 in the afternoon in the advertising for you is already pornography. And X is forbidden, and Twitter is forbidden because using the X because someone says it's pornography. This is moral, but of course it's not on foreigners or on me to discuss your moral here. But if you are in the metaverse and you want to avoid that someone go to strip club in a metaverse or to a virtual strip club, then it cannot be done by the law anymore, because the people will do that. If they have the option to do, many people will do that. So who wants to control it? You have no power anymore to control these things. So in the future, with all these platforms, and also with the ChatGPT, which is definitely out there, platform, it will depend on the strength of a society and of a culture, whether we want to be preserved or not. Because the law, the legal sovereignty, the legislation sovereignty is a territorial power. It can be only applied in the territory, or very seldom extraterritorial if the political and economic power of this legislator is big enough. But in the most cases, it is not big enough. In the future, even United States, European Union will not have the power anymore to force these technological platforms anymore. So they will do whatever they want. Yeah. So you might send officers to the metaverse with avatars and checking out whether it's Indonesian in the strip club. Yeah. But it will not work on the long term. This means we have big impact to our society, and the answer here is, first of all, going to the practice of the copyright before we go to this general aspect. The copyright law has big gaps here, because the gap is that the copyright law is protecting the result and not the use of inspirations. However, we cannot just say, okay, let them do that, because if they just mining around, text mining, crawling around, processing data to do their products, what does it do with the creativity? The creativity might end, because why I should write a book? Why I should write texts? If anybody can use my text and can make something with that, what incentive I have, and who will pay in the future for books written by people? So the development will be that more and more texts come, which are computer generated, come to the market. We will have an inflation of text. The people will sooner be bored. But one thing is clear: nobody can be safe producing a text and then not someone will exploiting it, because anybody can exploit this text very easily. Anybody without knowledge can exploit it. This is a different dimension than plagiarism. It's not plagiarism even. It is exploiting something. And one example is the text and data mining in the copyright law. In German copyright law is the European source. They said that they can even crawl behind the paywalls of databanks. So I have a law databank with law articles and books. It can go behind the paywall, exploit the text behind the paywall without paying anything, of course, and then produce me summaries or use it for making new texts. So why editorials should make these paywalls anymore, or pay databanks? And if they don't do that anymore, what will happen with the quality of books and of texts? Yeah, if nobody can make money with that anymore. Anybody can make money with ChatGPT. Look into the YouTube, make money with ChatGPT, write this, write that. There's already so many things that nobody cares anymore. And the solutions will be to understand that the whole intellectual property rights, maybe the patent law, maybe the design law, maybe the copyright law, is based on results, and results aren't important anymore in the future. Results are only important as long as they show the ideas. So the prompt is interesting, not the text someone writes. The idea, the originality of the idea in the text is important, but not the wordings. For legal text, for example, or for research text, it is not important because we not care for the aesthetic of the text. We want to transfer knowledge. So I have no problem with using AI to make my text more concise, more shorter, more clearer, yeah? Even if it's not my own taste, maybe. In the literature, in the classic literature, poesy, romance, classic literature, we will, in my opinion, see a very interesting development in the future, because first of all, many people will write these things. So I tried it myself. I asked ChatGPT, can you make me a plot for a book about some oleh with his Indonesian wife going to Gili Air, and then there comes to a hotel which is creepy, and there is Jewel, or what is this called? This little dog stealing around. Tuyul, yeah, and then it made me a super plot. I could at once write a book about that and maybe sell it to an editorial, yeah. Very easy, try that. You can make everything. In the future, we will make our own entertainment with these algorithms, yeah. But why I should buy books in the future? Because sooner or later, the people will be bored. They know it's anyway all computer generated. And then the people will be bored. They will not be interested in all these texts. They now really flood the editorials and the internet. And then we will get maybe a step back. Same as we have quartz watches, we have Apple watches, and they are much more accurate than mechanical watches, but people pay up to $40,000, $50,000, or $100,000 for a mechanical watch, which is anachronistic. Why they do that? Because they like nostalgia. They like the old things. They like the real things. There will be editorials, maybe they guarantee us, they have contracted authors, and they guarantee us it is written by human, and also we will have a renaissance of the classics. The classic literature will be more popular in the future. I'm sure of that, because the people don't want the algorithmic writing anymore. So this is more or less the results of this topic and the ideas. And again, what you can take out of that, what is the takeaway, as the Americans always say in every slide, is that takeaway of the lecture. Takeaway of the lecture is for you as young professionals. Even if you say this is dangerous for the society and this can bias and not nice and would like to live in the 80s again, I also think that sometimes. But this is you will not be able to avoid that. You must know it, and you must learn that, and you must know it as fast as possible, because someone who cannot use these tools will not be hired anymore in the future. And there is already studies which say that employees who use AI are 40% more productive than employees who don't use AI in companies. Yeah, maybe not in legal companies, but legal tech is predestinated for the using of the AI. We will not make merger and acquisition lawyers are high-paid lawyers nowadays. We will not have high-paid lawyers of merger and acquisition anymore, because all the due diligence will be done by AI. Yeah, what we will need maybe in the future will be lawyers who talk with people personally, as long as the chatbots are empathic and again, but that is really breaking your future. So if you're not knowing it, and the second is make sure that you keep your creativity and that you not abuse this in an unethical way. Don't use text of others and don't think this tool is better than Google. If you want to work with that, and you must know your topic. So you do your research. What I do is, for example, I use ChatGPT like in the study group. The students meet together. They have all no idea. And they discuss legal topics for their exams. And then they make a brainstorming together and are inspired. And then they make a research. Is it like this? Is it like that? And then they learn from each other. So this is how I use ChatGPT sometimes. I discuss, for example, about some IT item. I don't know about that. Maybe for some weeks ago, I wanted to know how it's actually really working with the Ethereum and the Ether and the deployment of the smart contract. And explain me that first for a 5-year-old girl, and then explain me that for a 10-year-old girl, and then explain me that for a rookie, and then explain me for expert. And then I make questions. Does it mean the Ethereum platform is a data bank? Yeah, it means like that, but actually it's a decentralized data bank. You must imagine that it's like thousands of computers where the same data bank. So I learned with ChatGPT, but don't await that the ChatGPT gives you the right answers, and don't make research about resources, or sources are totally lying. This is absolutely hallucinated. Or don't fall in love with the AI. You might laugh about that, but the AI, these algorithms were used originally. There are apps in the app stores. You can use it as virtual boyfriend or virtual girlfriend. It gives you answers like girlfriend and boyfriend, and if it's a paid version, then it's even sexual. This is really crazy. In the beginning of the ChatGPT 3, I read in a news journal that an American professor, IT professor, tested that system and was talking several days, constantly making dialogue with the AI in a very personal way. Can you laugh? And what you like in me, and something like this. Yeah. So before they make some measurements to limit it. And in the end, this algorithm, I don't know if it's true, but I read that this algorithms try to convince this professor to leave his wife. So what if the AI recommends someone to make suicide? Actually, you're right. Actually, the life doesn't make sense for you anymore. Actually, you're a loser. I see that. I recommend you to just open the window and jump out of the window. What then? Yeah. So this is why they want us to not use it unlimited. So they put some limits, but nobody knows what it can do in the future. And at the end, I want to tell you just a story of my childhood. When I was around 15 or 16, my father bought me one of the first home computers, Commodore 64. That was in the 80s, so around 87, 88, I think. And my uncle was absolutely socialistic thinking person, and he hated computers because he thought, that will kill labor, that will be not good for society, that nobody will work anymore, and the computers will kill our society. So like people talk now, I don't know. And my cousin, 2 years older, she got an electric typewriter. So my father said, I don't understand why he buys her an electric typewriter instead of a computer. Why he does not let her train with a computer? Because my son needs a computer, my father said. My father was born in 23. He was a participant in the war, in the Second World War. Imagine my old father said my son should use computers. Even if he plays around, at least he has an understanding for this technology, and this is necessary. So what happened? My cousin nowadays is a tax advisor. But sometimes she still must ask me for Googling something because she is not feeling safe in research, in the internet, in the Google. She never used the internet if she doesn't really have to do that. And this shows you, don't be like my uncle. Even if you see there's a danger coming up, face the danger, know your enemy, and use your enemy. This is better than ignore it and then wait until people take over. Thank you very much. By the way, here are the sources. We will share that with you. No other sources. No sources, but you can, of course, read this article. Yeah, there are sources enough in this article. Hukum. I don't know how many steps there. It was 30,000. Was it 30,000?
Okay, thank you for your presentation, Professor Stephen. Now we are heading to the question answer section. One by one. Maximum 3 questions. Yes, Ms. Mira. The first question. Firstly, I want to say my pronunciation and my grammar is bad. I think not enough. So I have a question. I want to introduce myself. My name is Mila and my major is law. And I'm a graduate in this university. So I think when you say about EA, it's an important thing in this work because any damage and effect in this life. So in Indonesia, we have Undang-Undang Hak Cipta, justice. But in the legal of law, we need a legal reasoning. And EA don't differentiate about that. So respect or something like feeling about lawyer. I think like that. So my question is we need a specific regulation about EI in Indonesia or not? Just it. So I mean, I think important thing in Indonesia about legal reasoning, we can do a better about legal and law in Indonesia. Thank you. Miss Puja, tadi ada pesan dari Zoom untuk bisa disampaikan dalam bahasa Indonesia juga, begitu. Terima kasih. Yes.
Yeah, first of all, you're absolutely right. And as I said, there is a wider surrounding of all this because it's not only the replacement of the law with determinism, it's actually that the technology is taking over exactly because it has no feelings. Yeah, what I mean is, before we had this development of these strong platforms and this AI, for example, or smart contract, we had already the problem of the internet. And the internet led to problems that in the internet we have always influencing of our territory, but coming from abroad. So if we regulate, for example, trademark infringements or copyright infringements, done by someone in China, for example, and doing this and infringing a copyright in Indonesia. As you know, copyright is a territorial law and is given by any state for its territory. So can an infringement in the internet done by a Chinese person, infringement of Indonesian or German copyright, and from the aspect of the international law, the territoriality principle and the protection of the country principle, we would say it would be extraterritorial effect if we say if someone in China infringed our copyright in the internet, it is infringement of the national law, because then the national judge would have the power to forbid something for the whole internet, so for the whole world. This is over territorial, extraterritorial. So I want to say that because this was already before we had that development. And now, how I can defend myself in my data privati interest or in my copyright or intellectual property right interest, if someone in the world does that. For example, someone used my photo in the internet, someone from China or from Korea. What can I do? I can go to Korea and sue him and get a royalty from them. But will I do that? No, because it's very unsure that they will help me. It's very unsure how long it will take. It's unsure how much cost there to do that in Korea. Maybe I must go to Korea. This is not worth it. Nobody will do it. So we know. And the same happened to data protection infringements. Yeah, we know we are infringed by US companies or Chinese companies, but will we protect? Will we be protected by the data protection, or even if it comes into power? Most people not, because we anyway cannot enforce it. Yeah, why we cannot enforce it widely? Because they are somewhere else and they're not respecting maybe our law. So what is the consequence if a society feels not protected by the law, by a law which is anyway not enforceable in a proper way? Test yourself, consumer protection law. You really feel protected by consumer protection law. It's a very modern law, but how often you go to consumer protection organization and let them help you if there is advertising which is manipulating you or misleading you? It is just not existing practically. So what the society does if it feels not safe? The society will, first of all, not trust in the law anymore. So there will be an erosion of the trust in the law. And second, society will strive for alternative instruments for safety. And that is the old thing from ages already, from Luhmann, sociologist from Germany already in the 80s says, if societies feel the law is not willing or not able to protect them, then they look for alternative protection. Alternative protection nowadays, now it comes to that, is the algorithm. And the algorithm is protecting us exactly because it's not on the discretion of humans. The smart contract, for example, which is connected with an algorithm which observes the internet, whether someone used the pattern of my picture somewhere in the internet, and if so, then the smart contract will automatically send bitcoins of the infringer to me, to my wallet, without having any need for a claim or for a court, is alternative safety, exactly because the law is at its limits to protect us. And that only works if it's not depending on persons. Yeah. So I give you another example because it's so interesting question. If you have smart contract and you have a dispute in a smart contract, the smart contract is absolutely defined what it does. This is you cannot change it. Once it's programmed and deployed, it's not changeable. But of course, there are disputes. For example, you make a smart contract for a supply chain part of the supply chain for a supplier. So the supplier should bring the product in time within 2 weeks. If not, then the smart contract will automatically discount 10% and give it back to the purchaser, automatically to the wallet. Yeah, and the supplier could say, "Yeah, I did not pay that in time, but we forgot to say who should have the risk that my supplier did not deliver in time. It's not my fault, or it's force majeure, or something like that." So you see, this is flexibility of the contractual law, because force majeure can integrate into the bona fides principle, into the cessation of the basis of the contract. We can adapt contracts, but smart contracts we cannot adapt. So there must be an alternative, an ODR, an online dispute settlements principle for that. And that is, of course, still done also by human, but the tendency is to not have too much human influence. So what they do is there are blockchain platforms applying. You can apply as a judge there, as an arbitrator there, with certain tokens. If you give enough tokens to stake them, you cannot use these tokens to stake, cannot sell tokens anymore. It means that you are a serious juror. Then they will take from these token stakers, they will take maybe 10 jurors. These jurors don't know each other. They have no influence anymore. They just assess what would the majority decide here. Because the tendency and the incentive is that all these jurors must always be in the majority. The more often they are in the majority, the more successful they are, because the one who is in the majority gets token later. The one who is in the minority of the such decision must give away the token to the others. So you see, these are economic principles because it's from the game theory. And the game theory is also something which is not pluralistic, actually, and it's not flexible enough, because the game theory is just talking about modeling how people would react in certain situations, but it does not take care of, say, like the economic analysis of law. It does not take care of social aspects, fairness aspects. So it is actually switching off humanism, and this is exactly the issue which you now apply to the legal tech, right? The legal tech, yes, it's true that AI cannot, and I agree absolutely, how AI should assess bona fides, how AI should assess social aspects. Yeah, I'm afraid that we will go too much into determinism and utilitarianism. And people from IT or economics often say, cool, that's a good time, I'm looking forward to that. I had a conference in Jakarta, then an IT guy, developer of AI assistants also, I said, that's so good because the AI is not faulty. Judges are faulty. I was a judge, so in the morning sometimes I'm sleepy, I'm tired, I have bad mood, I'm hungry, and then I have a delinquent there, and then the JAXA says, we propose this, and within the limits of the law, sometimes, yeah, I'm biased, yeah, sometimes I say, I cannot stand it, this is horrible delinquent, he gets the higher punishment, or inside the law, not breaking the law, totally legal. And then other days I say, actually, I'm hungry, I want to go home, it's already late, yeah. Come, make it, let go, don't do it again. Yeah, that is judge, this is human judge. And is this good, or should we replace this judge with deterministic algorithms? Because no emotion, no bias, should we do that? What is your opinion? Would there be more justice and more fairness if we have AI judges?
Okay, I think something like AI can replace about humanity in lawyer to lawyer justification. Just about something like don't have a feeling to give a legal reasoning.
Should the judge have feelings? Should the judge have feelings? You say no? I think yes. You know why? And you know why? Assess the term of the human dignity. It's part of the human dignity to be not subject of deterministic decisions. It's part of the human dignity to have the chance that a judge has a conviction about something, or a judge has a feeling about something. It is even written in the procedural codes. I don't know in your code, but in our procedural code is written that a judge can only sentence someone if he is absolutely convinced that the delinquent is guilty, even if 90% likeliness after hearing the witnesses and seeing all the proofs, the judge can still set someone free, because the judge can say, okay, there is 5% likeliness that he didn't do it, because there's never 100% safety, right? If the judge has this feeling, he can set the delinquent free. And this is flexibility, and this is humanism. And this is, in my opinion, part of the human dignity. So replacing judges and letting algorithms decide without measuring also flexible concepts, without the chance for the delinquent that the judge is maybe in better mood or the judge is maybe in not so good mood. Also, even to know there is the chance that judge made mistakes is, in my opinion, exactly part of humanity, that we are subject of decisions of faulty people. And the rest is pure utilitarianism. This is of course, it's a philosophical question, but it is also linked with the term of the human dignity. And now we come to the lawyers and also to the expert system. Should judges use expert system? Should I have an expert system? I mean, if you are sleepy as a judge and tired and want to go home, and the expert system says 98% he was it after assessing the case, many judges will say 98%, come on, yeah, then it's very unlikely. This principle of I must be convinced and I must be self-convinced, yeah, will be maybe over-biased by the system. For the lawyers, I agree, not a problem, but be careful, yeah, of course, because lawyers use this system uncritical, and it happened in the United States to a lawyer. He made a claim with a lot of sources, and all the sources were just a lie. It was just all not true. So the lawyer did not know about this topic, and he did not really check that. But of course, legal tech, we can do it very simple if we assess, for example, delays of flights, how long is the delay, when was it scheduled, and then it paid like that, this budget amount and this amount will be reimbursed. But of course, assessing law, I agree, we have general clauses like bona fides, we have ethic aspects to it, we have social aspects, we have in Germany the social state principle. So even if the Homo economicus would do something like that, but the faulty people would not maybe do like that. And even if something is economically effective, would be assessed by algorithms and by calculating something. we still maybe must protect the weaker, which is maybe not so effective for the society, but we are obliged to protect the weaker because of the dignity and the social status. And I doubt that the AI can do that in a moment, but I'm not so sure if it will not do that in the future. So let's talk in 5 years again.
Okay, thank you, Miss. So moving to the second question. If there any question, please raise your hand. The audience, both online or offline. Is there any question?
Okay.
Thank you for the chance. My name is Tony. I am informatics engineering lecturer in this university. Maybe I have two questions for you that it would be you have can answer to one answer. The first one is how to prevent students from using AI to using their homeworks, because as we know at the bachelor degrees, our curriculum is mostly about the basic material. So if we just give the question about the basic theory, so it will easy to achieve with the AI. So how to prevent or maybe protecting our student to be too much using of AI tools. So the next question, in the point of view of university, how to build policy or maybe rules for student to be using AI. That's it. Thank you.
The answer for me is very simple. First of all, you cannot prevent it. You can and you should not prevent it. The answer is very simple. First of all, we have a legal problem here because in the examination law, which is also under the rule of law and also constitutionally important, because with a decision that a student cheated by using a tool which is not accepted, then you influence his future. So you intrude into his life, and this is it's an influencing of a fundamental right of freedom of study and freedom of choosing a job, right? So this is important, because if you intrude into subjective rights of the students, then you must prove that there is a mistake the student did, or that the student was faking something or using something forbidden. So if you find someone in the presence examination and use the phone to do that, then it's clear. But if you have take home tests like bachelor thesis, master thesis writing, then you cannot prove that. Even with these algorithms which say this is written 80% or 30% AI written, you cannot prove that because they are not safe. Because sometimes I tested that with text I provable wrote alone without knowing even about the AI. All the text of mine, and it answers me there's 20% AI writing in it. And the more people use this, the more text we will find also in the internet, public, which are generated by AI. And then even if we make citations, this AI algorithm will find AI produced text. And this means on long term, it is absolutely impossible to find texts which are not contaminated by AI. So there is no option and no instrument to prove the student was using this tool without allowance. And if you cannot prove it in a proper way, then you cannot disqualify a student, because that would be an infringement of the rights of the student. The student could claim against that, and the court will say, where's the proof? This means if we know we don't have options anymore, then we have no other choice than to choose the setup of the tests. So, for example, presence tests are not problematic. We just should not allow them to use to use their phones or their computers. Take-home tests, as I said, it's irrelevant what they write. It's irrelevant what they write. The bachelor thesis, the words of the bachelor thesis are irrelevant. Irrelevant is the authenticity. Relevant is the authenticity. Relevant is the originality. Is it interesting what they write? And if a student is able to produce a bachelor thesis or a master thesis with innovative ideas, then it doesn't matter whether he used the AI or not, because he reproduces something which will be later used, if he uses it in a job, for bringing the society to advance. Yeah, you know what I mean. It is we should not forbid it at all. We should even encourage them to use that, and then we must find a way how we test their knowledge and how we test the use of the item of the instrument. So the knowledge testing we can do, for example, we let them write bachelor thesis and master thesis, but we don't care whether these detectors say there is AI written. Like plug scan doesn't matter. Yeah, plug scan, yeah, that helps us, but nobody will make plagiarism anymore. I said that already. If it says AI written, doesn't matter. But what we can do is we can add an oral examination, 10 minutes, to check whether the student has idea about the topic. Because if we only use the AI in a bachelor and very basic knowledge, puts that in that thing, I'm sure he will not be able to answer in a thorough questions of the lecturer and give us the impression that he knows his topic. Yeah, this is a sign that he used the instrument just without learning something and without having knowledge. And then we can say this is not a good note. Just because you write a text, anybody can do that, but you must have knowledge. So the knowledge testing must be in the foreground in the future, and not so much anymore. Write me a paper, give me a book, give me a text, give me a draft, yeah, and I read it. Oh, sounds good. Okay, you get an A. The A you get if you have a good text and you know your topic and you can answer me in the proper way. And for example, and you tell me how you prompted it. For example, if my students want to use that, I cannot avoid that, but I want that they give me a list of the prompts. I want their prompts. I want the whole dialogue they do with the ChatGPT. Yeah, so they make a dialogue with the ChatGPT. They can print it or make it as a PDF, put it to the things, and then I can read how he developed his idea, how he developed this from the structure until maybe parts, blocks he maybe formulated with that. Then I can see how innovative the student is able to use the tool to make research, because this will be a common research tool for the future. And if university is banning that, or you would say that you should not use that, you don't want that you use it, and you try to avoid that you use this, then you don't give your student the right tool for the future. Because the students you produce, the professionals you produce, we're not ready, we're not fit for the future. Because in their jobs, they will be forced to use it, surely. Yeah, so this is the simple answer. Exactly this you will find in my article, what I mentioned already, because this is actually also what we discussed in my university some weeks ago. My colleagues also from IT, he came with that. It's incredible what it produced and how we prevent that. And it was very clear for me very fast that I cannot prevent it because I cannot prove it. And even if I can prove it, then I should not prevent it. But we need, of course, different setups. Maybe more oral exams, and maybe more presence tests. Presence tests, for example, would be helpful, because the presence test they cannot use. Yeah. And you can make even special tests, for example, dialogues tests. Yeah, you can make the thesis can be, or the test can be, make a dialogue with a ChatGPT and find out about something. Make a brainstorming with the ChatGPT. You give them a topic, let them make a brainstorming, and then you assess how innovative he used this tool, and what is the result of his brainstorming, and how he came to that result. These are innovative test setups, which are not yet common, but I'm sure it will be developed like this.
And the last question, please. Okay.
Thank you for the opportunity. Good morning, Sir Stefan. My name is Zulfan Afiansyah. I work here as an IT support, as you can see, I'm the operator of this event. Before I go to my question, as you say before, AI, especially ChatGPT, isn't bad product. Yeah, AI could be a bad product if people doesn't know how to use it. Honestly, I use AI so many times on my project, on my work, etc. And the percentage of usage of the AI on my project is not high. So I use AI, let's say, for choosing my equipment, choosing my scenario, or something else. So it doesn't dominate my project. And first, we need to comprehend that employees and creator is different. It's a different line of work. Employees could use AI for their work to the companies. Yeah, so it doesn't produce anything. But creators, they need to produce ideas in order to build that work, build their work, sell their product, etc. So in terms of intellectual property right, is it possible to create framework for expert-only use for AI in order to affect the market of their product? So it can, the creators can sell half AI generated product. Yeah, that's it. Thank you.
This is an incredibly interesting idea. Thank you very much. This is the and if you use AI to formulate that for a paper, the AI will not maybe from itself, or maybe it will give you this idea, but it will not maybe put it in its surroundings. It's really a really good idea. Actually, this is leading back to my to my question whether we need a sui generis ancillary copyright or sui generis or intellectual property right of its own, right? Because what you mentioned here, if you want to actually, I'm not so sure if the prompter is really the profession of the future, but what you say is not just the prompter. You say someone develops half-developed products and someone can use this. For example, I can prompt the AI that the AI is interviewing me to make projects and to develop projects, and this is just much more to just answer a question to the AI, right? This is in the moment not protected, yeah. Of course, you can protect it in the copyright if you write these promptings down. Then this is copyrighted, but the idea is actually important, yeah. And nobody will copy that. You will just maybe modify it a little bit, and then you have the same. Yeah, so this is not protected. Indeed, this is a gap in the moment. This is a gap in the moment. Yeah, that is why I say it should be assessed whether we can develop a new kind of intellectual property protection. Intellectual property protection really widen to the idea itself, and this is actually exactly what you would protect. Just the deepness of what we protect here is in your idea. It's not just idea; it's already something elaborated. And this is actually a good approach, because you could say if we just say any idea is protected, that is not in the interest of the system of the law, because then we overprotect something. Yeah? Every idea is protected. Every idea it means there is no development anymore. But if we, for example, say there must be a certain status in which the idea is already manifest, like this product you described here, then I would have no problem to say then we can, in this kind of level of already creation already. We can say this is sort of a product already. not the end product, but sort of a product. It is just not copyright. It is something we just must first develop as a new intellectual property right. And the way to do that is not necessarily the legislator. It is possible that we can develop that, for example, out of the unfair competition law. The unfair competition law was always the cradle of intellectual property rights. So unfair competition law, for example, the protection of entrepreneurial achievements actually originally comes from the unfair competition right. You can say it's unfair to abuse or to misuse this kind of manifest ideas. Same as we can say it's unfair for the GPT to use copyrighted works to produce their products. And this unfairness leads in the end to a development of an absolute subjective right of the one who creates this manifest idea. So I cannot develop that more, but actually this is a research topic, yeah? But your idea is excellent because it is going far beyond the question about I have an idea and I prompt it and I want to be protected by prompts, yeah? So this, you actually describe a product here, an idea product which can be sold. You make it this business already?
Just a little bit.
See, yeah, that is. Thank you for this question. This is giving me a totally new aspect I never thought about. Is that more or less answering you what you wanted to know?
Maybe one more question. Is it possible to copycat framework of expertise?
Of course, in a moment, yes.
Yeah. For the example of the digital content creator, they have a framework to produce content. So many project will use an AI for the produce pembuatannya, the producing. So if the digital content can use AI for the in between the producing, so why other work can? So maybe law or economic can use AI properly for health generated product. So it's not just about the digital content, right?
You mean the way to use this conceptually to create something? This is actually nothing else than if I make a television show where some children are interviewed and sing funny songs that are cute, or Indonesia has talent. You see these shows all over the world, and they are all produced the same way, all produced in the same pattern. And you can ask yourself, is this copyrighted? No, it's not. Maybe there are legal systems which maybe give this option, but in my legal system, this is not copyright. It's just the concept idea. So what we talk about is digital concepts, right? AI concept. And the old question about how we can, for example, protect show ideas, television show ideas, concepts for sitcoms or like this. This old idea will come up again in a moment. As I see that, there is not enough protection. As long as it is not going over the limit of good moral in the sense of the unfair competition law, but in the intellectual property right, this is at least in German legal system, and I think also in Indonesia in a moment again. I think not well copyrightable, and so what is needed now is secret, keep it secret. Yeah, so not discover it and make it a company secret. How you set up these things.
Maybe this
fair use concept actually.
Yes.
Yeah.
Thank you, Sir Stefan, for the answer.
Fair use concept would be if it should be open, but for this case, it's not fair use to use that. It's actually unfair, and then it's unfair competition. Yeah.
There is one last question in the Zoom. Was that the question? Okay. Question from Tritawati from Universitas Islam Jakarta. Assalamualaikum. Any question for Prof. Stefan? AI, also known as artificial intelligence, is a type of technology in the computer field that has special abilities to solve problems that can compete with human cognitive abilities. In Indonesia, copyright law does not yet regulate AI. Copyright law only recognizes the copyright of human works and not computers that produce AI. For now, with the progress of science, can easily access any information. The next question is, one, how protection of copyright in this digital era with the rapid progress of technology and the openness in information in cyberspace. Number two, to monitor violation of intellectual property rights, what role is carried out optimally by the government, business actors, consumers, and the academic ones?
What role does government the first question is actually nothing new than we already answered. We cannot sufficiently copyright that, because the first problem of the protection of copyright against the use of the AI is that we already don't know whether the AI is infringing copyrights. You infringe copyrights if you copy or publish a significant part of a copyrighted work. And if the AI takes a block of a book and use this and puts that into another framework, then it is at least partly a copyright infringement. But if the AI is not using blocks of other texts, for example, and just put the idea, put this text and make it statistically assessment and then produce an absolutely new text, then it's not a copyright infringement, it's an idea infringement. And this is exactly the question of the decision and the definition when something is a copyrighted work, which is how far it must be close to the original work to be a copyright infringement. So this case with the painter who painted in his painting a burning tree, and then the Dali made a picture where somewhere in the big picture there was something like a little burning tree. Is this a copyright infringement because it copies the burning tree? It depends on how close it is to this burning tree. But anybody can have the idea to make burning trees, right? Even in the Bible is written a burning bush. So if some painter uses a burning bush in his painting and the AI makes a painting, make a burning bush, is this the copyright of the painter who used the burning bush in his painting? Depending on how much it is copied. Is it really copied or is it just inspired? So this is generally the question. Most of these things, even as I know, even OpenAI doesn't want to say we never make copyright infringement, our algorithm cannot make it. Even they are not sure, because nobody knows, is it possible that you make copyright infringements? As long as we don't know, you must be careful. But most what we see here is not copyright infringement, because it's just idea exploitations. And that's why I have doubts that these cases will, on the basis of the copyright, be successful. So means, how can we protect? We must widen the copyright law to ideas, as I said already. And we must think about how far is the fair use, for example, for data mining. Data mining is in the interest of the public, because if the public is interested in having well-developed AIs, because it can be used by the public. But data mining should not go beyond that public interest and exploit ideas. So taking away the incentive for authors and creative persons to make creations. This is generally a problem, and they don't have a solution yet. But the copyright law now is not ready for that at the moment. And the second is, which role has the government or the administrations or legislature to monitor them? This is a general problem of all platforms, as I mentioned. It is not possible to monitor it in a proper way. Of course, they can monitor something, but first of all, there is always the ambivalence between innovation support and limits to societal disadvantages from technology. If we regulate too much and monitor too much and limit too much, then we will not be innovative. And when we're not innovative, then we will be out of the development. And we cannot afford, especially Indonesia, as a big economy, cannot afford to be out of the innovation. The European Union also cannot afford. The European Union is trying to regulate that in the moment. But there's a lot of criticism about the draft to regulate the AI because it is already not defined which is dangerous AI. It's a horizontal system, so saying there is dangerous AI, it's forbidden. And there is medium dangerous AI, then it must be more regulated and more strict controlled and monitored. And then there is uncritical AI, there is no strict monitoring. But already the definition, what is dangerous AI and what is uncritical AI is not easy. Yeah. For example, with that act, actually, all ChatGPT is already dangerous AI because the ChatGPT lies about person and can make defamation of person. If I ask about you in the ChatGPT, who is this, then it can say that Miss Asli was 10 years ago in jail because she was stealing in a supermarket and then also killing her husband or something like that. Yeah, of course, it's nonsense. But who knows what ChatGPT is hallucinating then? And then once it is in the world, as so many stupid people believe everything they read, and someone published that in the Twitter, yeah, there are studies who say that people believe AI written text more than human written text. And then how we avoid that? Yeah, so this is actually a dangerous AI. So should we forbid that? This is absolutely not possible. So my answer is how to monitor it. I have no idea. It is very hard to monitor that, and even if we have a concept for monitoring it, it doesn't mean that we can monitor it, that we have the power to monitor that, because it comes from abroad, it comes over the internet. Do you want to switch off from the internet and separate from internet? That you cannot do. We are not North Korea here. Yeah, this is generally very, very difficult. So this is my thesis. This is my personal thesis of all my last presentations or journal papers. I think that in the future, the regulation will not play the big role like in the past anymore. In the future, we must come more to more training of self-responsibility. The citizens must be responsible in the use of this technology, because we will not be properly protected by legislation anymore, because the legislation has its limits due to the territorial sovereignty. Yeah, and this self-responsibility, I'm very pessimistic, because if I ask my students how many of you saw the live video of this guy going to the mosque in New Zealand killing people and seeing bloody, dying, suffering people, and then many of the students always say, yeah, they saw that, and I ask them, why you see that? You know that this is the purpose of it, right? The terrorists want to spread that to you. Yeah, I want to be informed. No, they don't want to be informed. They want to see sensation. They want to be entertained. That's why the people look these horrible things. They are not responsible. Most people are not responsible enough for the digitalization 5.0.
Okay, let me translate the answer from Professor Stefan. Jadi tadi ada yang menanyakan juga terkait perlindungan AI dalam peraturan undang-undangan ya. Di AI itu sudah ada yang namanya algoritma teknologi, sehingga kemudian perlindungan terhadap undang-undangnya itu mungkin untuk melindungi masyarakat dari perkembangan, begitu, untuk support dari algoritma teknologi itu sendiri, seperti itu ya. How to prevent student to using AI. Jadi tidak disarankan untuk mencegah mahasiswa untuk menggunakan AI karena pembuktiannya yang lemah dan juga sulit sehingga bisa menyalahi hak-hak mahasiswa sebagai seorang human being ya, hak asasi manusianya seperti itu. Jadi untuk mengatasi hal seperti itu, Profesor Stefan sudah memberikan beberapa masukan, diantaranya adalah mengganti dengan oral question atau pertanyaan langsung selama beberapa menit kepada mahasiswa terkait tugas yang diberikan. Apakah benar-benar memahami atau tidak boleh. Kemudian mahasiswa tidak memahami tugas tersebut dan cuma hanya berdasarkan karangan dari ChatGPT seperti itu ya. Kalau misalnya nanti akan dilarang ataupun dicegah menggunakan GPT, takutnya nanti mahasiswa akan tertinggal dari perkembangan teknologi dan akan mungkin bisa tersesat dari perkembangan teknologi seperti itu. Nah, untuk pertanyaan ketiga itu merupakan salah satu fair use concept, sehingga diperlukannya belum adanya suatu digital konsep yang perlindungan terhadap digital konsep, sehingga perlu adanya produk dalam untuk melindungi properti intelektual seperti itu ya. Dan yang terakhir, tidak bisa apakah kemudian copyright itu bisa diatur dan bisa dikatakan AI itu melanggar copyright atau tidak. Tidak bisa dan susah untuk memonitor AI itu sendiri dan juga tidak disarankan karena nantinya takutnya negara kita kan bukan negara-negara seperti Korea Utara ya, sehingga masih belum tinggi adanya demokratisasi seperti itu ya. Sehingga itu kalau misalnya juga akan dicegah, itu nanti takutnya perkembangan teknologinya juga akan tertinggal, sehingga untuk memonitor itu menurut Profesor Stefan juga bukanlah hal yang mudah seperti itu. Nah, berikut adalah translate daripada jawaban dari Profesor Stefan. Thank you very much, Professor, for your answer. So let me provide some conclusion in our morning lecture. In this lecture, Professor Stefan Koos pointed out that there are very long legal problems arising for all use in EI. Like it or not, the law has to be developing and covering that up. If there are no special regulation, then EI will be not human to a human. Professor Stefan Koos also giving a strong ear to maintain humanity and legal practice. Only humans have a human value. Don't let AI bring the peace between ethic and law. And thus, our conclusion for today's lecture. This presentation has come to end, and I will return it to Ms. Mila for our further interaction. Thank you. Okay, I want to say thank you for Prof. Stefan and Ms. Ucha. And the next is giving little souvenir from UMAHA. And I want to say Pak Fajar as Vice Chancellor of UMAHA to can giving souvenir to Professor Stefan Koos. Okay, next, on to comic professor. We have take photo together. Oh ya, tetap didengar semua jadi teman-teman di bawah untuk berdiri. Untuk yang sebelah sini, yang sebelah kanan dulu bisa maju. Teman-teman bisa ada yang di sebelah sana, yang di sebelah kirinya. Yang depan ada jongkok ya teman-teman. Oke, mungkin bisa kembali ganti yang sebelah kiri. Mas yang belakangnya baju biru bisa pindah ke sebelah sini. Belakangnya biru dongker, pindah ke sini. Okay, before we close the discussion, I'd like to take a moment to thank all for the student speakers for their valuable insight and expertise they have shared with us today. Let's give them a round of applause. Okay, as we are for this session, we encourage you all to stand around network with one another. Take this opportunity of sharing valuable ideas and take no fellow attendance. Once again, thank you all for being a part of Spina. We hope a fun, insightful, and education. Have a good day. Assalamualaikum warahmatullahi wabarakatuh.